Hello and welcome to Newswire. I'm Ayza Omar. Now, corruption is seen as an epidemic. It's seen as a global failure, especially in this time and age. It's an evil we see in society. We see it in governments. We see it in every part of morality and ethically. It's weaved quite deep in. Once it's there, it is very hard to fight it out of societies. It causes a chain reaction, a downfall in countries. It starts disintegrating society in its own. So how do we handle corruption in this day and age? What international laws are out there? What is the World Economic Forum saying in its recent report on the most corrupt countries and the most successful ones? For that, I'd like to first welcome our guests. Barrister Saif is here joining Newswire on the phone with us and is an international law expert. Thank you for joining us here. Let me start off right off the bat. The international law as is globally accepted. We have the International Court of Justice also that plays a certain role. But before we get into the nitty-gritty of it, how do you as an international law expert see the biggest challenges in battling corruption on a government scale?
Well, international law, in fact, deals with states who are members of international organizations, in particular the United Nations. And in particular, whenever there is an action that a state wants to take vis-a-vis another state, the first question that state is confronted with is the privilege that a state enjoys as a member of international community, and that is there enshrined in the UN Charter, which is that the immunity a state has vis-a-vis its jurisdiction. So a foreign state or another state cannot interfere in its jurisdiction without its consent. That is the biggest challenge in international law, and that is why the development of international legal jurisdiction or prosecutorial jurisdiction is always restricted. It has not developed with the pace that we would have wished for. The reason being that most of the states, they claim immunity from international jurisdiction, and they usually make this claim that their own legal system is sufficiently competent to handle crimes, whatever, be that a corruption-related crime or terrorism or any crime. This prohibition on granting access to international bodies is usually one of the reasons that international crimes are not successfully prosecuted. Corruption, if it has international dimensions, it does become an international crime. And in order to address it effectively, we have one major convention in international law that is called the United Nations Convention Against Corruption, the UNCAC. That is the most recent and the most effective convention. However, it is also, once again, as I said, dependent upon the surrender of jurisdiction by member states who are parties to this convention. If they agree to allow another state or international agencies to come and probe and investigate, the matter would be comparatively conveniently handled. But in most of the cases, states refuse this permission. And that is why it becomes easy for the criminals or for those who have violated the law to hide behind jurisdictional issues and carry on with their activities.
And here I'd also like to welcome our other guest here, Mr. Francis, joining us from London as also a lawyer and an international law expert. Something our guest just spoke about, Barrister Saif here. One of the main issues that face governments, especially when not being part of an international convention where international law can take place. Besides that, there are other key issues that come into play here, especially when we're talking about governments where the entire system has collapsed, especially when it comes to law and order. What are the key issues that the international community then faces in trying to rein in a rogue state?
I think, well, it's very difficult with rogue states because really the first question for a rogue state, say, for example, Somalia, a rogue state's probably a slightly difficult and undefined term, but a failed state might be the way I prefer to put it, such as Somalia, for example. The first priority there is to put the basic institutions in place And the interesting discussion about the UN Convention Against Corruption and international means of dealing with corruption internationally and international law is of importance. But I think the priority here needs to be to develop the legal systems of individual countries. Now, clearly we have an extraordinary system, in terms of being very rare and unusually used, system of dealing with international crimes, which is a slightly different issue in terms of torture, crimes against humanity, with the International Criminal Court and war crimes. That I think is proportionate, and that also depends on the member states accepting jurisdiction, albeit that international warrants can exceptionally be issued. When it comes to corruption, I think one of the issues here is we need to be careful that the international regime doesn't fall victim to overstretch. Corruption is usually best dealt with within the country within which it occurs. Now, obviously, the difficulty with that is where the system within those countries is unable to deal with it or unwilling to deal with it. The best way of dealing with that, realistically, the only way, bearing in mind the need for cooperation with the convention, as your previous speaker said, is to develop and build and encourage fair legal systems within those individual countries. The other issue, of course, is extradition and increasing the availability of extradition as a means of dealing with these crimes, and perhaps in relation to certain international corruption, making that a crime of universal jurisdiction, which is a matter that an individual state can declare. For example, in the United Kingdom, we've declared that crimes against the Female Genital Mutilation Convention and crimes against torture are international crimes of universal jurisdiction, where any the courts in the United Kingdom or in England, Wales, and in Scotland and in Northern Ireland can try people for those crimes wherever they took place and whatever citizenship that person had. So I would say, in answer to the question, the priority must be the individual member states securing and developing fair trial systems within them and encouraging their development. And secondly, extradition. I think those are the first two priorities.
Right, and let's take this debate a little more, make it a little more general. And it was interesting, you pointed out the definition of a rogue state, failed state. You mentioned Somalia, but if we were to look at conflict zones, and Barrister Saif, I want to ask you this first. Specifically, for example, what is happening in Yemen? We see that it is one of the world's biggest humanitarian crises unfolding, and while billions have been pledged and a lot of aid has made it across from places where it was originally not getting through, but there is this big problem of theft, and there are a lot of allegations, there are a lot of proofs coming across who is responsible for that. But as an international community, this is also a form of corruption, surely. Where does the international community, or where are those organizations that can actually do something about this?
Well, you see, insofar as Somalia or Yemen are concerned, I mean, these are states where there is a complete breakdown of legal system, administrative and legal system. My understanding of corruption as such is that corruption is not in itself an issue. It's the manifestation of bad governance. When your governance system fails, one of the outcome is corruption, financial corruption, when money is stolen from state institutions or from wherever it is, and it is. I mean, the whole process takes like the form of a crime in the sense that it is all. I mean, illegal. All kind of illegalities are involved, whether they are within the country or outside the country. So Yemen is just an example of a state which is in a very bad situation. The law and order has almost come to a breakdown because of the civil war. I mean, but even in countries where apparently the system is okay, like there are many other countries, but where the efficiency of the governance system has been affected adversely through whatever means, and the corruption is taking place. Now, what do you do? It's actually, I mean, international law can only help to the extent of the powers given in certain conventions, and also on the condition that that the concerned states must have signed those conventions and must have ratified them. So this is the biggest problem because most states usually either have not ratified them, or even if they have ratified them, they have not been able to come up with the required set of laws or amendments in their own legal systems in order to ensure the implementation of those international conventions. For instance, the United Nations Convention Against Corruption, well, it's an effective mechanism for tracing and then prosecuting people involved across the border as well. However, in order to prove that the connection of these people with that stolen money or stolen wealth, that itself is a big challenge. For instance, if money is within the country, okay, then prosecution and discovery of that money or in whatever form it has been kept, that is like issue number one. But issue number two is that if that money has been taken abroad, then you have to invoke the procedure relating to money laundering. Now, for money laundering, there is this problem of proving a predicate offense that the person who is being prosecuted must also have committed for money laundering must also have committed a predicate offense, whether that's corruption or terrorism or whatever it is. So, there are like these several layers of tests involved, and all these have to be completed or successfully prosecuted in order to get your hands on the stolen money. And once it is parked in some form in another jurisdiction, then you have to handle the challenge of dealing with their legal system. And prove it beyond, at a level, you require the kind of proof which discharges your burden of proof in that particular jurisdiction. So that is why there are so many complications and time. A lot of time is taken. Like I personally was involved in a case where I won't get into details, but there was some money, some corruption related wealth that was transferred from India to United Kingdom, and it was almost an impossibility to prove it, to prove the predicate offense first, and then to go through the British system to prove that this money that was brought to United Kingdom was not legal. Then to repatriate that money is another challenge. So it's international law is growing. It's developing. It's not yet attained that state where one can be satisfied that, okay, now all the legal system is at your disposal and you can simply invoke a particular provision and then go for it. There are many loopholes, there are many obstacles, and they become even more complicated when you're dealing with countries like Somalia or Yemen or, for that matter, Syria. There are reports that the billions of dollars worth of wealth has been, in one form or the other, been transferred from Syria and the conflict zone to various countries illegally, Middle East, European, Western Europe, and all that. So it's the tracing of it, and then making proving that the wealth that has been parked in a certain jurisdiction is the result of an illegal action in its home country. There are challenges, yes, but the law is developing, and I'm sure that mechanisms will be in place soon, which will make it easy for prosecutorial agencies to get hold of that.
And Mr. Saif, what you mentioned about the different layers, the different kind of tests, especially when there's a change in jurisdiction, whether it's geographical, or also the big issue about member states not being, or states not being part of corruption conventions. Here I want to ask you, Mr. Francis, why is it that in this time, I understand that this is a developing, evolving law internationally, but where does one stand on bridging these loopholes, especially at a time when there are so many conflicts across the world? And this is not just conflict zones like Yemen and Syria. I'm talking about dishonest or fraudulent conduct by people in power who might be voted out or flee a country, but we still really have to face so many roadblocks in trying to get them to justice. Where do you see us heading in the near future in trying to bridge these roadblocks?
What was interesting in the last explanation was that the arrangements and trial, the difficulties that were mentioned, were in relation to two countries, two common law countries, India and the United Kingdom, with extradition treaties, and which were dealt with within the parameters of those extradition arrangements. I presume, I think it's a reasonable presumption. So that is one way, and that is an important way. And through extradition treaties, one necessarily requires, one state will necessarily require that the other state has a fair legal system, because it will want to ensure that its nationals are treated fairly by that other country. And that is why extradition treaties do take some time and are not arranged with countries without fair legal systems. So in and of itself, the process and the development of the extradition regime is important. The other point is the responsibility of countries with fair legal systems to be able to deal with crimes dealt with that have an international element outside their jurisdiction. So I entirely agree about the difficulty within Syria and within parts of Iraq that have been occupied by ISIS with stolen antiquities that are part of the heritage of those countries. One way in which we could deal with that, fair legal systems can deal with that, is to make it an international crime to trade anywhere in the world in these sort of artifacts, and to ensure that where those artifacts are found, a civil court can provide that they are returned to the country, or at least to a place of safety before they can be returned to the country if it is in a state of civil war, such as Syria. And in addition, that it can try for criminal offences those who are found to have done so. Your other contributor, entirely correctly, dealt with the difficulty of the burdens of proof, the different types of burden of proof that may apply, and the difficulty of proof. Well, that is always going to apply. It is of some note that on occasion, the criminal jurisdictions can change the burden required by the state where facts necessitate it. And money laundering was used as an example. In the United Kingdom, there are, in relation to money laundering legislation, presumptions raised against the person found with a certain amount of money, and the limits can vary. And at that point, the defendant must prove to the balance of probability that the money is not the proceeds of criminal conduct. If it is, the money can be confiscated. And in certain circumstances, it may be that presumption applies in the criminal context. And in fact, the European Court of Human Rights and the British courts, or the House of Lords, Supreme Court now, and the courts in England and Wales and Scotland have approved reverse burdens being applied in certain circumstances. So that is another way in which it can be dealt with evidentially. But I again go back to the point I made earlier, that I think extradition arrangements and taking responsibility as fair trial countries for prosecuting these crimes, international crimes, and ensuring that they are punished wherever the individuals may be and wherever the crime took place, are important priorities, quite apart from the fact that we need to ensure that the basic state institutions and apparatus applies in those states where these happen, because without that, there is no prospect of fair trials within those jurisdictions.
So closing international loopholes in laws is one of the basic issues we're facing globally. Now, Mr. Saif, coming back to you, the World Economic Forum, they came out with a list late 2018, I believe it was October, where they basically said one of the least corrupt countries, and this is something that has been persisting over the years, is perceived to be Denmark and New Zealand. Now, just to ask you, what is the basis behind these perceptions and them rating so high on the least corrupt countries list?
Well, I believe countries like Denmark and Sweden or Switzerland, I mean, they are calling them to be declaring them to be least corrupt countries. One is comparatively easy because they have a good system of law, but they're also very, very small countries as opposed to countries like India and Pakistan. And then their governance system is quite efficient. our governance system has many weaknesses. So wherever you find the offense of corruption being committed on a regular basis, you will find that it is done in countries, or it happens in countries which are big countries, where there are governance, administration-related issues due to any reason, whether war or economic problems or socio-political unrest. But these are, such countries. Denmark and these are stable and small countries, so of course they will always appear on top of the list.
But I'll ask you, Mr. Francis, we heard what Mr. Saif was saying just earlier. He also mentioned that good laws are important, but really good laws are across the board. That's what every government brings in to install even a better, more independent judiciary, at least mostly across the world. But implementing those rules, where do we go wrong, especially if it's the government where the corruption is stemming from?
It's very difficult where the government is the corrupt force, particularly because the government normally has considerable interactions with the judiciary. It's inescapable for there to be some interaction with the judiciary, because the judiciary will inevitably be appointed by the state, and the terms on which the judiciary serve will inevitably be to some extent regulated by the state. However, that is regulated is a matter of the constitutional arrangements in individual countries, but that's an inevitability. So the state, without the government being willing to ensure that its agents are susceptible to judicial interference and scrutiny, it's impossible to move forward, which is why in ensuring that those states don't have means of dealing with their own people outside their countries, or people who are transgressing, who are committing crimes against them, without making their system fair, is a very good means of trying to improve those countries' systems. In relation to laws generally, of course, it is only the first step to have good laws, as you indicated just then. Indeed, it's often said that the Constitution of the Soviet Union was, on the face of it, had a certain amount of fairness, but in practice, obviously, that had borne no relationship with the truth. That the reality is that unless laws are implemented, unless there is a fair and uncorrupt police system, unless there is a fair judicial system, and unless the judicial system, the judiciary rather, are independent of the government, despite the fact the government will always have some connection to appointing them, unless those conditions are met, then there is little hope for an uncorrupt system that deals with things. But we also need to remember that these are all grades and gradations. As Seth just said, Denmark and Switzerland are very small countries. They're extremely rich countries as well, which helps, because the salaries of the judiciary and the salaries of the police force can be at an appropriate level that means that they're less susceptible to corruption, and that's a real issue. So we shouldn't despair, and the perfection is that we shouldn't let the best be the enemy of the good and the better. But we should strive to improve systems, and systems will always have an element of corruption. It's impossible to eradicate completely, but what we can do is try and build up the institutions gradually. Try and build up the sense of responsibility internationally. Try and ensure that countries realise that if they don't have a fair system, they will suffer both economically and in terms of their ability to punish people who transgress against them. I think that is the best way of dealing with this. International conventions can be helpful; they have a role, but I don't think they're the most important way of achieving proper.
Definitely not a very easy way to approach it is a very complicated process, definitely bringing international and local together. But here, Mr. Saif, I want to ask you, especially with regards to your experience with the National Accountability Bureau, of what Mr. Francis was talking about here, making a robust police system, a strong independent judicial system in order to rein in corruption within countries, within governments. But just reflecting on your experience experience, this also brings into question whether additional supplemental accountability institutions are needed, and with respect to your experience with the National Accountability Bureau, please.
Yes, well, I agree with what Francis has just outlined. You see, as I earlier pointed out, when you talk about corruption, always keep in mind that corruption is an offense or as an act, illegal act, where somebody in authority or in control is involved, and his or her actions by the use of or the misuse or abuse of his or her authority is instrumental in making sure that offense is completed or takes place. So first of all, you are in cases of corruption, you are dealing at the national level with people who are in the position of authority. In countries where, I'll go back to my previous argument that it is the breakdown or the failure or the incompetency of the administrative system, of your governance system, which allows the person to be able to exercise his authority in such a way that he conducts an act of corruption, or he commits an act of corruption. Now, in countries like Pakistan, yes, that is why the international conventions, most of the international conventions, like I'll give you example of the corruption against drug trafficking. It's an international convention which requires countries to implement laws, strict laws, and to establish institutions to handle that menace. Similarly, in case of corruption as well, all the member states which go ahead and ratify the convention are obliged to. It's a positive state obligation. They are required to establish institutions which investigate and prosecute corruption-related cases. In Pakistan, we have had these experimentations with corruption in different forms. We had an act, Establishment of Corruption Act in 1947, under which we had an anti-corruption department in all the provinces. Well, the result wasn't that good. Then we had at the Saab Commission in 1990s. Then we went ahead and established National Accountability Bureau, which is still in existence. It has a very, very, in my opinion, a powerful law behind it. The chairman of the National Accountability Bureau is a very powerful man, and he can pick up anybody and pick any case up for investigation and then go ahead and prosecute it. But the issue again is that when you are dealing with people who are in authority at one point or the other, and they are in a position to manipulate evidence, to pad up evidence, to distort evidence, then you are dealing with people in authority, and therefore it goes out of the ambit of an ordinary crime. It becomes an extraordinary situation which you are dealing with as an investigator and then as a prosecutor. Now, and so far as the courts are concerned, our judges are usually trained in dealing with ordinary criminal cases, murders, robberies, rape, this and that. But corruption is a white-collar crime. It's generally defined as a white-collar crime, and it requires a lot of knowledge of financial transactions, accounting, auditing, forensic auditing, even computer data forensics, and then applying that knowledge to the case before them. Because, as I said, it requires a lot of there are lots of complications and lots of complexities involved, and also in most of these cases, there is a foreign element involved in one way or the other. Like money has been received, for example, an act has been done in Pakistan, but
please hold on to that thought. Saif, sorry to interrupt you there. I want to continue with this, but quickly need to take a short break. We'll be right back. Welcome back. You're watching Newswire. Now I'd like to welcome our guest, Justice Nasra Javed Iqbal, who is here in the Lahore studios with us. Thank you for joining us. You've come at a key moment because we were just speaking to international law expert Barrister Saif. He was commenting on how it's very difficult in light of his experience with the National Accountability Bureau, that when we're dealing with high-profile corruption cases and then the judges sitting on those cases, it's a real catch-22 situation. It's not just about, of course, we're trying to fix this, we're trying to catch the accuser here, but are they equipped enough to deal with these high-profile cases?
Well, there are several issues involved with the way the NAB operates, and you do know that the National Accountability Ordinance was passed by executive fiat. It has never been passed by the competent legislature. And the first thing that the parties who are so-called democratically elected said in their manifestos that we are going to have a new accountability law. But when the first party came for 5 years, they had a vested interest in not doing anything about it. They didn't. Then when the next party came, it was the same situation. Now we have a third. This is going to be the 11th year that we have been with the same law. And now the present elected government says, or rather the Prime Minister says, that I am going to amend this law. Now, it's well known that if you have a foundation which is not properly placed, the building or edifice you raise on it is bound to go awry. So the best thing is to make a new law, start from scratch. And whatever faults there are in this law, you see to it that they don't recur. But somehow that is not being addressed by this third democratically elected government. They are not doing anything about it. And one of the aspects which was yesterday also being criticized about the National Accountability Law is that they permit plea bargaining. So if a person has maybe stolen 10 billion, he says, all right, I'll give you 2 billion and let me go. And they let him go, which means the state forfeits 8 billion for that 2 billion. And in that 2 billion, the National Accountability Bureau officials have a cut. I mean, this is recognized.
Let's bring in Mr. Saif and hear his comments on it. Have you been able to hear what Ms. Nasra is saying?
Well, she's right to an extent. I agree with her. But then if you look at the nature of white-collar crimes, the problem is the possibility of proving a crime. As we were discussing, me and Francis earlier, there are so many complications involved and jurisdictional issues involved that generally the prosecutorial agency, be that NAB or any other, they usually come to the conclusion that if we go ahead with this trial, it would take us nowhere, in the sense that maybe after a few years of trial and hard work and financial expenses incurred, the end result would be that the accused would be acquitted. So if the accused himself agrees to pay a certain amount of money and wants to be discharged, of course, that is one option available. But he is, according to Pakistan's NAB law, the accused is considered to be a convicted person. So he is convicted technically. He's not a free man. But the point is that some of the money is recovered from him. Now it is up to the NAB and the court, which is trying that offense, to give a go-ahead whether or not that amount offered by the accused is acceptable. If the court thinks that the amount is not enough, then the court can waive that off and go ahead with trying him. But you see, just one last comment in this respect from my side would be that in criminal prosecution cases, whenever the prosecution agency decides to go ahead and conduct a trial or prosecute a person, in addition to the criminality or the gravity of the offense, there is one most important consideration, and that is called the public policy consideration. The prosecutorial agency has to think whether it is in the public interest to go ahead and try this accused or not. And public interest does involve the amount of
policy,
money
right, the public policy consideration. I'm sorry I have to cut you there, but I want to pull in Mr. Francis there. He's speaking to us, also as a national law expert from London. If you could shed some insight into what you heard as the National Accountability Bureau functioning as, and the loopholes, if I may add, present in it. I mean, it's a real catch-22 situation. Does it make you wonder that even the people in charge want to fix the situation in the first place? Why are there such compromises available, such loopholes left in the name of accountability?
Well, I can't comment, unfortunately, on Pakistani law and the way in which it was set up. I did have a couple of possible responses to Mr. Justice Iqbal, the two observations. Firstly, in relation to the agency taking cut of the return, I think if that is dealt with in a very strict and measured way, which is that the agency obviously requires money in order to operate, and whether it requires an incentive to operate is a difficult question, because that might put it under inappropriate pressure. But retaining certain amounts of the money that is confiscated is not uncommon in common law jurisdictions, I think, although I'd be corrected if I'm wrong, but I think that in some instances, agencies in the United Kingdom can take a proportion of money confiscated in order to pay for themselves. And where budgets are tight, which they are in any country, but I'd have thought particularly in Pakistan, it is important that they have funding, but it obviously must be done in such a way that goes to the agency as a whole and doesn't benefit any individuals in particular. As for plea bargaining happens in every common law jurisdiction. It doesn't happen in England and Wales, for example, in the way that it happens in the United States, which is, I think, very objectionable in some instances, because you see enormous reductions in sentence in order to persuade people to plead guilty, whereas here it's done on the basis you receive a third discount, typically from a prison sentence or a fine, which is to reflect the fact that you have accepted your guilt and avoided the need to put individuals through the stress of cross-examination and involve huge efforts of the investigatory authorities to investigate the crime further, provide the evidence, and so on. And I also agree with Seth that it is difficult sometimes to convict people, and you need to take a realistic approach. And it may be that in some instances you take a plea to a lesser crime, which is why there may be a considerable difference in sentence, but that may reflect the fact that it is impossible to prove the higher crime, or very unlikely. As for public policy considerations, the view taken by and large...
No, hold on to that thought, Mr. Francis. Let me come back to Ms. Nasra here. Do you agree with his statement that this is, well, first of all, the plea bargaining, but before that, what he said, that the cut is really just to maybe pay for the
provide incentives to the officials to act in a proactive manner and be efficient. But that doesn't encourage non-corruption. It is a form of corruption itself. I have known, or I've heard of people who are working for NAB, who have pushed for money all the time, and suddenly they become very lush. And how do you account for it? What the commission that they get? And it doesn't go to NAB, it goes to the individuals who have been following the case.
So it doesn't go to the institution.
No, it doesn't go.
That would be the only way.
And now there's one more thing.
Mm-hmm.
What happens to the money? There must be transparency. You know, Pakistan is very heavily indebted. Right. And like this case of Raisani, he was secretary of the provincial government in Balochistan. And they went into his house, and behind the waste paper baskets were all full of money. Behind the geyser there was money, behind the cooking range there was money, behind the toilet there was money. The money was in drawers, in cupboards, everywhere. They took counting machines from different banks, and the machines broke down. There was so much. But what I want to say is that when they took all that money, and it ran into millions and millions, and there was dollars and there was euros and there was Pakistani currency, and he had automobiles, a whole range of them, and houses, a whole range.
But that's
don't know where, but we don't know where it went. And later on he said, I'm going to make a plea bargain, take this much of it and return me the rest. The gall of the person to come out, because that the law permits it apparently, and he was trying to take advantage.
So in your experience, how do you beef up accountability without keep on adding institutions that are taking people to justice, and in order to catch corruption in its tracks?
Now the law says, and all anti-corruption laws worldwide have this provision. If there is a public servant, public official, who has assets beyond his known means of income, there is a presumption that they have been earned by corrupt practice. It's a rebuttable presumption, and he has to prove. The burden of proof is on the accused. It is not the state or the prosecution who has to prove that he was corrupt. It's a rebuttable presumption that he has assets beyond his known means, like this man Raisani, and they were all recovered. So he has to prove from where he got them. He didn't have the kind of income which would allow all those assets. But why then is not that pressed into service, rather than this that the prosecution has to prove? The prosecution has this part burden to prove that he has to show, you know, what we call the track, the method from where he got it,
Right,
or
the trail,
the
money
trail,
trail.
the money trail, the money trail. And if he can't prove the money trail, then he's
But this is one
not
example.
an accused.
This is one
then
very
he is
obvious
a
example,
person
right?
who has become from an accused, he turns into a convict.
Right.
It's as simple as that. So why should we go into plea bargaining, and why should we go into this commission? I think this just adds up to further malpractice within the institutions which are trying to encourage proper practices. And it is really going into all kinds of circles without really gaining the kind of substantial advantage that the state should yield. And the third thing is there's no transparency. All the money recovered from Raisani, we don't know. All the money recovered by NAB in the pre-bargain system, there was this very corrupt man from Wapta, and he went to Hollywood or someplace like that, and he made a villa and all kinds of things.
Right.
And he did a plea bargain, gave 20 or 30% of whatever
percentage of what
he
he
had
actually
earned.
stole. Right.
And the rest of it he kept, but the 20-30% he gave, we didn't
clearly plea
know
bargaining
what
is
happened.
not-
No.
right, it has
but
its-
there's no transparency where the money goes. No explanation. We don't know what NAB did with the money. So much recovered.
Mr. Saif, let me pose this question to you. Bringing accountability within an accountability court, within a system that is responsible for bringing people to justice, where are the loopholes there, and how does one make it possible?
Let me clarify this last point as well. In addition to answering your question, this provision of plea bargaining, it's an international provision. It's included in most laws worldwide. Number one. Number two, plea bargaining, in fact, is when an accused surrenders a certain amount, he has to approach the court. Both the National Accountability Bureau and the accused have to file an application before the Accountability Court. And it is for the judge to decide whether to allow that plea bargaining or not. And if yes, if he allows it, what is the amount that he has to pay? The amount is not paid to NAB. It is not. It doesn't go to the NAB's kitty. It goes to the government, the exchequer, and then the court grants him, the accused, the permission to be discharged. In the sense, not discharged in the sense that he's acquitted. He is considered as a convict. He is disqualified from holding a public office for 10 years, and all the other sentences are applicable to him. The only thing is that he is then released from detention, and he's now a free man. He can go around and do whatever he wants to do. But he's considered a convict. So number one. Number two, the Supreme Court has recently, last year, prohibited plea bargaining. Now, there is no provision of plea bargain, although it is still there on the statute book, but it is not practically implemented because of certain irregularities that were reported in the case that Justice Nasir Sahiba just mentioned in the Balochistan case. So it's now something that we should not waste time discussing, because it is no more an active provision. It has been stopped by the Supreme Court of Pakistan. Number one. Number two is that insofar as accountability mechanism and its improvement is concerned, you see, in order to eradicate corruption, number one, corruption is a historical crime. It has been in all societies, and I believe it will remain in all societies to come.
Okay.
You cannot 100% eliminate or eradicate it.
It is very difficult to catch, right? Just
Yeah,
very
but you
quickly,
can-
we're running out of time.
But you can address it. But as I said, instead of focusing on accountability mechanisms,
Okay.
you should improve your governance system in your
Improve
country.
the governance system. Thank you so much, Mr. Saif, for joining us here. And I want to quickly bring you in, Mr. Francis, for your closing remarks on, is it a human impossibility or is it a system failure? How do we bring both of these two problems, eliminate these two problems?
Nationally, in individual countries, I think we need to build up institutions, build up a sense of responsibility, a sense of the importance of independence, ensure that there are not, I said Mrs. Justice Iqbal just said that there were individuals obtaining personal from plea bargains, which is obviously completely objectionable and very different from it going to the organisation to fund it and to fund its investigation. That's nationally. Internationally, we need to ensure that fair trial systems have a cooperation, both within their extradition procedures but also that they learn from each other, because certain countries will be dealing with certain types of corruption and can have very many lessons to give to other countries which do not, but may have those systems and those
An evolving
problems
process where countries learn from each other. Definitely. Thank you so much, Mr. Francis. So sorry to cut you short there very quickly since we're running out of time. Justice Nasra, you've heard their arguments. There are so many loopholes. It is a human impossibility to close these, because it is the very nature of human to be greedy. And then you're talking about a white-collar crime as corruption.
And the 20th century has unleashed a monster of corruption. Every country on the global corruption list index, I think maybe there are two countries. One is extreme north, and that is Finland, and one is south, that is New Zealand. They are taking position number 1 and 2 in integrity, and all the others are going down to the scale to 180 countries or so. How low we have gone, that is sunk actually, all the countries. And we have an international multilateral treaty called UNCAC, the United Nations Convention Against Corruption, 2005.
Right.
And that provides mechanisms how countries can interact with each other and help each other to recover the gains which are with corruption.
And
if
sorry, I'll have to cut you
Pakistan
here.
has signed that treaty, but we have ratified it by the cabinet, but we haven't passed it into local legislation because everybody is affected.
Everyone is affected. And well, we have to end the show. It was a very interesting debate here. Thank you so much, Mr. Saif, Mr. Barrister Francis, and of course, Justice Nasra, for being here all the way in Lahore studios. We'll see you tomorrow. Till then, goodbye.